Good morning, everybody. I'm your host, the Supreme Litigant, and I am back again with another video for y'all. Um, First off, I just want to tell everybody thank you for subscribing to my channel. I really appreciate the comments, the feedback, the thumbs up on the content. If you're sharing my content, I appreciate that. And I like to thank you for watching these videos and learning. I know this stuff isn't easy for y'all, but just don't give up. Okay, it's gonna take some time, but sooner or later it's gonna click for y'all because it clicked for me. So before I begin with this video, please go ahead, if you haven't already, subscribe to my channel, and go ahead and hit that like button. I really appreciate that. Now, the topic of this video is called a bail bond is a contract, or a bond is a contract. I made a few videos, and I was telling y'all that that they're contracting with you. I think it was the state is a person, part 2. That's the video that I mentioned that in, I think. So I want to show you these cases, that hold this. And I want you to see this for yourself. Let me go here because I got some case law that I want y'all to see. And then I'm going to read some more of these other cases too for y'all. I just want y'all to see this stuff. You see this? I read about 4 or 5 of these and then I go back to the other screen. But this is something, every time I find some good case law, I save me a page and I copy and paste that case law on here. So this is good case law too. But anyway, you see where it says the recognizance of bail constitutes a contract and where executed by a surety amounts to a contract between that surety and the state. And here's the case right here that supports that conclusion. As such, the traditional rules of contract law are applicable. The recognizance must be construed according to its expressed terms. They're talking about the expressed terms in that contract, in that bail bond. That's what they're talking about. Here's another one. This one's in Alabama. This is the case citation right here for the one I just read right here at the bottom. This is another one right here in Alabama. A bail bond is a contract requiring the principal to appear in court at a certain time, and the sureties are not, as a matter of right, released from their obligations under a forfeited bail bond by the surrender or the principal after judgment. We're going to go down some more. I want y'all to see this shit, man, because I keep telling y'all they're contracting with you. They are doing business with you. That is what they are doing. But they're doing business under the name of the state. Or let me rephrase that. They're doing business with you under a business name that sounds like the state in which you are allegedly a citizen of, or a resident of, or whatever you want to call it. That's what they're doing with you, man. They're doing business with you, man. Don't let these people trick you and say you not crazy. These people are doing business with you. That's what they doing, man. A bail bond is a contract between the court and a surety whereby the surety acts as a guarantor of the defendant's appearance in court under the risk of forfeiture of the bond. Right there. There's the case right there. The surety is bound by the terms of its contract. As stated in Rice, the recognizance of bail constitutes a contract and, where executed by a surety, amounts to a contract between that surety and that state. And there it is right there. It's right there, man. Right there. Let me go back over here. I'm going to read y'all some of these. I just read y'all that one. That one's in Alabama. Let me see. Did I read y'all? I think I read this. So I just want y'all to see this stuff. These are the cases. Like if you want to go and read these cases, you would I would copy and paste this into Google, and type in the word case text after that, and this case will pop right on up, and you can go and read that case. So what I'm about to do is I'm gonna click on. I think I got a pretty good one that I saw over here that I want to click on. I want y'all to read it, and I'm gonna read it with y'all. It's not this one, but I'm gonna read this one too. This was in looks like this is in South Carolina. We have held that that the state's right to ease treatment or forfeiture of a bail bond issued in a criminal case arises from the contract, i.e., the bail bond form signed by the parties. The parties to such a contract typically include the defendant, the person or company which acts as surety for the bond, if any, and the state and local government entities identified on the bond form. We routinely have applied contract principles to resolve various issues arising in bond forfeiture cases. And then here's the case right here that support their argument right there. This right here. The state's right to ease treatment is governed by contract, and a surety is one who, with the defendant, is liable for the amount of the bail bond upon the forfeiture of bail. See that? Do y'all see this stuff, man? This is crazy. Crazy, crazy, crazy. It is the contract that provides the basis for the state's right to bond ease treatment. In upholding partial ease treatment of bond, the court applied the contract principle of impossibility of performance where a defendant was extradited to another state. And I'm not going to click on it and read that. But I just wanted y'all to see that. There's another one on here because you're doing business with the state in its corporate capacity. That's what you're doing. They like to call them sovereign. They are not sovereign. These are public servants. They are trustees. They are not sovereign. Here's another one. This looks like, where was it? This looks like it says Minnesota State versus Rodriguez. It's probably the case that I just cited. Anyway, a bail bond is a contract among the bonding company, the defendant, and the court. The bonding company acts as a surety for the defendant as principal, who is obligated to appear before the court, who acts as creditor. See, this is business. They're doing business with you, man. As a legally binding contract, traditional principles of contract law, such as the doctrine of mutual mistake, may be applied. However, the district court correctly determined that no mutual mistake of fact existed here to avoid the bail contract. We also affirmed the district court's refusal to reinstate and discharge the bond in this case. Applying these principles, the district court concluded that a bail bond is a contract because there is an exchange of promises and consideration among the surety, the bonding company, the principal, which is the defendant, and the creditor, the court. The district court described the nature of the bond contract succinctly. Now, this is a good case. I would go and read that case if I was you. I think I'm going to keep that. I'm going to keep that. I'm going to leave that right there. Let me go down some more. And there's another one in here that I wanted y'all to see. I'm actually going to click on that case and read it. I think it's this one. This is a federal case. Yeah, it's this one. It's one of them. In reviewing the bail bond, a court should be guided by the following principles of construction, which have generally been applied to bail bond contracts. First, a bail bond contract must be interpreted in light of the applicable law of the state in which the contract was made. Boom, there's the case citation for that conclusion. Second, a bail bond contract is to be strictly construed in accordance with its own terms. Third, like any other contract, a bail bond should be construed to give effect to the reasonable intentions of the parties. Let's see if I can find something else on here. If it's going to show me some more. Okay. No. There's another one. I think I got to scroll down a little bit more. Yeah, I'll read this one. Texas courts have recognized that bail bonds are contracts between the surety and the state, and that the contract consists of a promise by which the surety, by the surety that the principal will appear before the court in exchange for a promise by the state that it will release the principal. See, this is business, man. They doing business with y'all, man. These people are contracting with us, man. That is what they're doing. Here's another one right here. In Gavin, our Supreme Court explained a bail bond is a contract between the government and the defendant and his surety. See this? Y'all see this? In this case, the language of the bail bonds evidences for each bond a contract in which the defendant promised to appear wherever his appearance might be relevant. You know, it's like these are the case. Like if y'all want to read these cases, y'all can go and read these cases. This is the case citation for this case right here. Crazy. These people are doing business with you, man. That is what they doing, man. They doing business with you. This applies to appeal bonds too, because a bond is it doesn't matter what type of bond it is. It's a contract. Doesn't matter. It does not matter. Period. Doesn't matter. So I wanted y'all to see that. That will be the end of this video. I'll be live tonight on Blog Talk Radio. I'll probably do it either at 5 p.m. Central Standard Time or 6 p.m. Central Standard Time. And we can just talk about, I want to get back into, how to sue the police, because a lot of people have questions about that. So I'll pretty much be saying the same thing that I have always been saying when it comes to suing the police. We'll talk about that, because I'm trying to get y'all to understand how important the ultimate facts section is of that complaint. Everything else is pretty much just boilerplated. You can just copy and paste pretty much everything else with little requirements of you editing it. But as far as the ultimate facts section, that is the most important thing in that complaint. But I'll save that for tonight. Hopefully, this video explained to y'all by showing you the cases that a bond, a bail bond, is a contract. And these people are doing business with you. That is what they are doing. That'll be the end of this video. The Supreme Litigant is out. Peace.